Welcome to our VLG Law Immigration Minutes podcast, where we focus on giving you tips to navigate complex U.S. immigration laws without the politics. Today we will discuss avoiding the au pair 60-day pit. At VLG Law Firm, our lawyers have had the pleasure of working with au pairs in the United States over the past 2 decades and protecting the status of these bright, intelligent youth with great dreams and aspirations from around the world. The au pair program is a cultural exchange program run by the Department of State, also called DOS. The program permits youth between the ages of 18 and 26 years old to provide childcare to U.S. parents who are typically professionals, military and non-military executives, and business owners. The program is for 12 months, but DOS may approve a one-time extension of 6, 9, or 12 months if the au pair demonstrates compliance with certain educational requirements and files at least 30 days prior to the expiration of your visa. An au pair may also return to the program for a new 12-month period after remaining outside the U.S. for 2 years. Au Pairs of America is a primary placement agency for au pairs. The agency, based in Connecticut, uses its own U.S. Immigration Legal Counsel to prepare the J-1 visas for au pairs accepted into the program. However, in contrast, the agency unfortunately does not provide legal representation for the au pair towards the end of his or her stay, where the au pair is unable or unwilling to apply for an extension of au pair duties. We have seen this lead to the au pair accruing unlawful presence in the United States and lose her ability to receive any future U.S. immigration benefits. I will now share important tips that an au pair needs to guard against this ever happening to her. The following tips are essential so the au pair does not forfeit her U.S. immigration options or aspirations in planning for life after being an au pair. First, do not accept legal advice from an Au Pair of America staff manager or member. Only a separate private immigration attorney can accurately advise, as the au pair and agency often have a conflict of interest. For instance, the au pair agency needs to bridge the gap between the exiting au pair and the new au pair needed for the host family. This is paramount, of course, for the au pair agency's business. In contrast, the exiting au pair cannot and should not work even 1 day after expiration of status on the DS-219. Due to misinformation by the au pair staff agency, we have seen many au pairs fall out of status because they were told that there is a 60-day grace period to remain in the U.S. despite an expired stay. The au pair then falsely believes she may continue to work for the host family until the new au pair nanny arrives. At no time should an au pair feel obligated to work for her host family without the valid work authorization from the agency in the form of a new DS-19 extension. Secondly, talk to your host family about your J-1 visa well in advance of expiration. Host families in the United States are many times very understanding and helpful. We frequently receive calls from the host family wanting to know how they might help their au pair stay in valid status within the United States. The 60-day grace period is not status while remaining in the United States, and a private immigration lawyer can help the host family and au pair with concerns about childcare during the gap which occurs when an au pair's DS-19 or DS-2019 expires. Finally, the au pair should ideally consult with her own private immigration attorney at least 45 days before the expiration of one's J-1 visa, especially if there is any consideration to remain in the U.S. at completion of one's program. However, even if the au pair ends up remaining in the United States unauthorized due to misinformation about the 60-day grace period, contacting a lawyer as soon as possible is still very essential before you would depart the United States. An experienced immigration lawyer knows how to remedy and correct any unlawful status that might result. This legal step is insurance, so that as an au pair, there will be no issue in a few different issues. There would be no issue in changing your status to a change of status if it's student visa, or if you choose to be sponsored by a U.S. employer, that employer also can sponsor you. You can be permitted travel back and forth in a status called advanced parole. Also, if the au pair, which we've seen often happen, is engaged and they want to marry, they can actually marry even though the J-1 is a non-immigrant visa, and there's steps that can be taken. However, the status has to be 100% intact. Thank you for listening. This has been your Vassell Law U.S. Immigration Minutes. Our immigration lawyers are all members of the American Immigration Lawyers Association, and we provide initial 20-minute video consultations and encourage you to contact us today with any questions. Thank you.